Okay, ladies and gentlemen, hello from Germany, from Mannheim, and I'm very honored to be invited again to this great lecture. And first of all, when Gerhard Danneger invited me to this lecture, I was very pleased to get a chance to comment on this question. In Germany, the topic of internal investigations is currently of great importance, as Gerhard Danneger already mentioned. However, the lecture will focus less on the legal framework. It will mainly be about practical benefits and risks, especially risks that arise when companies leave the results of internal investigations to the public prosecutor's office. I still remember very well when shortly before Christmas 2011, a colleague asked me for advice in connection with the seizure of documents from internal investigations. It was the first time I was faced with legal questions of internal investigations, and it was about interview transcripts and other records that lawyers had prepared on behalf of an internal investigation, and which were partly with the company, partly with the lawyers. At that time, just a moment, okay, at that time, internal investigations in Germany were mainly known from the Siemens scandal. In this case, as far as can be seen, they had been carried out for the first time in a significant way in a German company. So at that time, short court decisions on this subject were rare. Only one decision by the Hamburg Regional Court existed in the publications. In this case, in connection with unfaithful acts by members of the management board of HSH Nordbank, this court, the Hamburg Regional Court, has upheld a very broad exemption from seizure of documents originating from internal investigations. The decision was strongly criticized in legal circles. Nevertheless, based on this decision, we also decided on an offensive investigative tactic. This in turn was only tolerated to a limited extent by the Mannheim Regional Court in a highly respected decision of the 3rd of July 2012. Now, nearly 10 years later, the questions that were significant at that time still arise in the same way, even if important decisions have been handed out since then. In particular, the decision of the Federal Constitutional Court in the Jones Day case should be mentioned. This case is connected with the clarification of the Volkswagen diesel scandal. However, in Germany, the usefulness and the usability of the results of internal investigations will be a subject of further discussions in the future. The reason for this is a draft of the so-called Verbandssanktionengesetz. You see, it may be translated in Association Sanction Act. It only exists as a draft. But this draft is to create statutory provisions for the first time in Germany that regulate the conduct of internal investigations. Especially, it provides that sanctions against companies may sanctions against companies may be reduced by half of the maximum provided for in the Act if the results of internal investigations are handed out to the prosecutor office. In addition, the case of appropriate internal investigations, the order to publicly announce the conviction of the company as a kind of naming and shaming must be admitted. Although it is not predictable when the draft law will be implemented, it can already be stated on the basis of current national case law and prosecution practice that in the case of violation of laws and regulations within companies, there is increasing, more or less intensive cooperation between the criminal prosecution authorities and those responsible for the company. Since at first glance, this is accompanied by a reduction in the workload of the investigating authorities, and since this development has manifold positive effects for companies, there's much to suggest that this development will continue regardless of the fate of the already mentioned Verbandssanktionengesetz. At first glance, internal investigations and cooperation between companies on the one hand and public prosecutors' offices on the other hand, based on internal investigations, appear to be a win-win situation for both parties. But however, the prosecution authorities should not lose sight of the fact that the victims of this win-win situation can be the individual defendants. But let's have first a look on the advantages of being able to access the results of internal investigations by the prosecutor's offices. In legal practice, internal investigations within companies are usually carried out by international law firms. I already mentioned John Stay and the other ones. They employ a large number of highly qualified lawyers. They do have almost unlimited investigative possibilities, and for that reason, they can examine the relevant facts fast and effective. Even cross-border cases in particular do not pose any major problems for the law firms. Elaborate requests for legal assistance, high costs for translations, and very time-consuming attempts to understand other legal systems do not delay the clarification of the facts. Nearly for every question, there will be a competent lawyer in the law firms. So, in the end, within a relatively short time, and therefore even more complex cases can be clarified. For this reason, and in view of the still insufficient human and financial resources on the part of the state investigating authorities, access to the results of internal investigations can be of great interest to the public prosecutor's office. This consideration may also have prompted the German legislator to grant very high penalty discounts to campaigns to companies that make the results of their internal investigation available to the state authorities. But in my view, however, this view proves to be superficial. A public prosecutor's office that takes its task seriously will not be relieved by handing over the results of internal investigations. At best, stage investigations are facilitated. For this assessment, it is first of all decisive that internal investigations are an instrument of clarification in order to obtain compensation for financial damage caused by violation of laws and regulations in the company. Of course, they are also intended to avoid further damage to the company. To this, excuse me, to this extent, the threat of a state sanction is also to be regarded as a damage that needs to be avoided. Therefore, internal investigations are at least interest guided. In this respect, no general suspicion is to be pronounced. Lawyers who conduct internal investigations are, according to the German understanding, an independent part of the legal system. Therefore, from my point of view, there is a presumption of factual correctness of the presentation by a lawyer. Nevertheless, I would like to report on an incident that occurred in a case I conducted against the German company suspected of corruption. In these proceedings, the company did not file a criminal complaint, but the company managers assured the public prosecutor's office of their full cooperation after the suspicion arose from other sources. In particular, the company made available the results of her own already conducted internal investigations. These included the transcripts of the interviews. However, for other reason, a search of the company's premises became necessary. And in this way, the files with the Word documents of the interviews were also seized. And the files were especially saved in correction mode. A comparison of the printed records of the interviews, which were handed over to the public prosecutor's office, and the files seized during the search, relieved that a large number of passages in the interviews have been deleted, especially those suggesting that the current CEO was also aware of the incriminated transactions. For sure, the example just described may be an isolated case. However, this does not change the fact that the public prosecutor's office must keep in mind that internal investigations are interest guided. Often, the persons who are held liable for damages on the basis of internal investigations will be the defendants in the state investigations. In most cases, they will not longer belong to the company they are alleged to have criminally harmed. At least they are suspended. For this reason, these persons usually no longer have access to their documents created in the company and their internal, especially, and their internal company email account. So in order to be able to counter objections by the defendant that exculpatory evidence is missing, it seems unavoidable for that the prosecution authorities must collect and view evidence on their own. This requirement is also not a result of mistrust towards companies' own internal investigations. This requirement only consider that the fact that the evaluation of evidence in an interest-guided investigation can already be subconsciously one-sided. Evidence that appears exculpatory from one point of view may not be perceived at all because of a different perception. In such case, there is often no malicious intent at all. From my own experience, I know that it's helpful to take different perspectives when evaluating evidence. You can't be deprived of this possibility if you restrict yourself to pre-selected evidence material. I'm well aware that there are certain rules for true and objective conduct of internal investigations. These are also partly reflected in Section 17 of the already mentioned Verbandssanktionengesetz. For example, it is stated that the persons contacting the internal investigations may not be defenders of the company or of an accused person. Furthermore, the persons conducting the internal investigations are to cooperate with the prosecution authorities without interruption and without restriction. After the conclusion of internal investigations, the results, including all documents essential to the investigations on which these results are based, as well as the final report, must be made available to the prosecution authorities. The questioning within the internal investigation must also have been carried out in compliance with the principles of a fair trial, which are specified in more detail in the section. And finally, the conduct of the internal investigation must be documented to the prosecuting authorities in accordance with the aforementioned principles. This may well be a catalogue of best practice for internal investigations, but who decides whether there has been uninterrupted and unrestricted cooperation with the prosecuting authorities? From whose perspective do we determine what are documents essential to the investigation? And finally, how must documentation of internal investigation be designed to give a true and objective view of implementation? The point remains an investigation that does justice to all interests, including those of the individual accused, cannot be determined by a potential party or or a person who has vested interest in the results of the investigation. And let me say, interpretive sovereignty with regard to the results of the investigations must not be given to the responsible persons of the interpretive sovereignty with regard to the results of the investigations must not be given to the responsible persons of the company and the lawyers who act on behalf of the company, especially with regard to the aspect of interpretive sovereignty. Quite difficult word for me, especially. I would like to point out another aspect that is likely to be significant in the evaluations of the results of internal investigations, the so-called anchoring effect. As we know, the anchoring effect is a cognitive bias that describes the common human tendency to rely too heavily on the first piece of information offered. If we recognize that the presentation of the results of an internal investigation carries a high risk of bias, the final report of an internal investigation will mostly present a conclusive and literally convincing picture of the evidence, the facts and the conclusions drawn from them are presented in a clear manner that leaves almost no doubt. This, moreover, is provided by a highly qualified law firm. If you see these results, it will require a great deal of effort and therefore also a high degree of motivation if you will change the point of view. For that reason, and all in all, I believe that internal investigations do not relieve the investigative work of the criminal prosecution authorities in the long term. A review of the results of internal investigations is indispensable. This is the only way to counter the danger that relevant evidence is only proceed in a one-sided way. The law firm's assessment of the results of the internal investigations must be recognized by the prosecution authorities for what it is, an interest-guided view of things by one of the parties involved. Not less, but also no more. In my point of view, it is therefore sufficient if only the evidence gathered in the course of the internal investigation is presented to the prosecution authorities by the company, not their evaluation. The company, of course, is free to evaluate the results of the investigations by our own. However, this cannot replace the independent evaluation of the investigations results by the public prosecutor's office. However, in order for the public prosecutor's office to be able to independently evaluate the results of the investigations, it must be ensured that all results are available. All results are available to the public prosecutor's office, not a pre-selected part of it. So that means that the data stored in the company's IT system must therefore be handed over to the public prosecutor's office in its entirety, without prior selection. This applies in particular to the email accounts, which are a very important source from my point of view. And also the private drives, data drives of persons who are suspects in criminal proceedings. Also, paper documents should be handed over to the prosecution authorities in their entirety and without pre-selection. In practice, this could be done by providing a kind of data room, as is known from the due diligence. And finally, reliable documentation of the interviews conducted within the internal investigations is also necessary. In my opinion, audio-visual recordings of the interviews are better than written records. In my view, this can convey a far more authentic impression of the interview. In addition, there is no danger that the answers of the interviewees, even unintentionally, will not be recorded. Just as a side note in that subject, I also prefer audio-visual recordings of the questioning of accused persons and witnesses in the state investigations proceedings. Unfortunately, the corresponding practice does not yet fully exist in Germany. If we have cross-border cases with internal investigations, the aforementioned requirements should be observed by all companies. The evidence from the states involved should be made available to the public prosecutor's office in such a way that it can be accessed without a request for legal assistance. I'm aware that these are very strict requirements. However, they combine the more effective investigative possibilities of law firms operating across borders with the objective evaluation of the evidence those obtained. That people who conduct the internal investigations in the company may feel that they have been reduced to being, let's say, all respect, they being stooges of the public prosecutor's office. However, the function as advisors to the company and their authority to evaluate the results of the investigations from their own point of view, both factually and legally, remains unaffected. At best, they have to accept that the prosecution authorities do not share these assessments. On the other hand, a company that is genuinely interested in an objective investigation of violation of laws and regulations within the company cannot object to such demands. It is preciously through the unshielded surrender of all evidence that it documents its unrestricted willingness to cooperate. So thank you for your attention.